You mentioned that 32 jurisdictions have now passed legislation implementing the NAIC model reinsurance collateral law. But the reality is that 4 years is a long time, and we're still at a point where major states like Texas and Illinois are not part of that. And so I was wondering, if you say that we need to avoid the variation between the states by reducing collateral requirements in a consistent manner, it looks to me like, by your own test, we're not close to implementing this, and the presumption I would have had was that that the pressure that would have been applied by the threat of a covered agreement might have brought everybody to the table. The worry I have is that since 1871, we've been trying to get the states to adopt a common framework. And give me your thoughts on why you think this is going to be done in a timely way and stave off the problems that I anticipate here.
So on the topic of credit for reinsurance revisions that have taken place, the process has been deliberate, it's been very methodical, and it's very measured and transparent in the way we are reducing collateral for foreign reinsurers. We have had 32 states. That's about 2/3 of the U.S. market, about 66% of the U.S. market in terms of premium. We have 5 other states that are seriously considering it and are ramping it up for their legislatures to consider, which will take us over 90% to about 93% of the market.
If you can get there.
Yes.
But I'm just going to, by way of example, if we went back through testimony in the past in terms of how many times we thought we were a year away from achieving this goal from 1871 on in terms of reaching unanimity, it hasn't happened yet. Now, 4 years may not seem like a long time frame by that standard, or certainly by congressional standards, to be fair here. But I'm highly skeptical that you're going to bring states into line based upon what I've seen in past performance here with respect to getting this unanimity.
Well, Congressman, I would point to the fact that we have yet to have the decision whether we would make the credit for reinsurance revisions an accreditation standard. So I'll give you the example that we just went through for Model Holding Company Act, a model that we developed in 2010 to allow insurance regulators access to the information from the holding company. That model was developed in 10, is an accreditation standard as of 1/1/16, and we plan to have all 50 states plus D.C. Having adopted that model. So as we, in November, start the conversation about accreditation for credit for reinsurance.
I understand.
That's a hammer we have, is my point.
Okay. Director McRaith, as you know, I shared this with you today, I sent a letter to the Treasury Secretary and the USTR calling for a covered agreement with the EU. Based on your diligent work on this issue, I assume you agree that such an agreement is a positive tool that the U.S. should use in attempting to tackle reinsurance collateral and make progress on the question of U.S. regulatory equivalency.
That's exactly right, Congressman. What we know is effective January 1st, 2016, the European Union, which is the largest consolidated market in the world, will be subjecting U.S. insurers to regulatory standards that differ from those applied to insurers domiciled in some other jurisdictions. A covered agreement will provide clarity, finality, and certainty for U.S. insurers that either are now or seek to operate in the European Union market.
Let me jump in on another topic. On January 27th, the Homeland Security Chairman, Mike McCall, and I sent an unanswered letter to the President asking how the administration classifies and defines different types of cyber attacks. Specifically, we asked whether the use of different terms like cyber warfare, cyber vandalism, cyber terrorism would impact the Treasury Secretary's authority to certify a cyber attack as an act of terrorism under TRIA. So I assume this is a question you have contemplated as part of the larger question, and I think a clear statement from Treasury on what is and is not a covered what is not covered under TRIA as it relates to cyberterrorism would increase certainty in the market and help encourage additional capacity for cyber insurance. Can you help make that happen?
Absolutely appreciate that perspective. The statute, as you know, does not specify what are the causes or types of terrorist attacks. And in 2007, when I testified as a state regulator in support of renewal of TRIA, nobody talked about cyber. So the fact it's not specifically listed does not mean it's not included. If an event, a cyber event or any kind of event, satisfies the statutory criteria, then it is eligible for TRIA certification.
Thank you, Director.
Gentleman's time has expired. With that, we go to the very patient gentleman from Michigan, Mr. Kildee.
Thank you, Mr. Chairman.